I opened up social media and I saw Carrie Severino, who's president of the Judicial Network, and she was going off. And I think she made some of the most succinct remarks on this, where she was getting into, like, for instance, how I was discussing, certain phrases that you could go back, I guess, and try to redefine everything, which seems to open a can of worms. She gave an example of that with the American flag. And she says, quote, an American flag could literally encompass a flag made in America, but in common parlance, it denotes the stars and stripes. A three-pointer could literally include a field goal in football, but in common parlance, it's a shot behind the arc in basketball. And she is going into how you're looking at redefining everything. And she said, and she cited Scalia as well. And she joins us on the phone because I want to make this, and Carrie, thank you so much for your time today. I want to make this accessible for people who, they're average everyday people and they have their 9 to 5, and their 9 to 5 isn't being an attorney. Because I think that this is so important, and especially the point that you made and that others are now discussing as well, that it seems to open this door, what Gorsuch has done, to go back and maybe perhaps like redefine and relitigate certain words that we thought had been settled because the time in which they were written. Is that an accurate assessment of maybe one of the biggest problems of this?
Yeah, I think you're right, and I have to agree with your assessment of Justice Thomas being, a great bellwether for is this decision right? I clerked for him, and I continue to think the world with him in terms of his logic. And the problem with this decision wasn't that he was saying, well, I'm just going to rewrite this text. Gorsuch is claiming to do textualism, to look at what the words are saying and say, I'm just interpreting the words as what they mean. But I think those quotes about what an American flag means and what a three-pointer means really get to the problem here. And those were from Kavanaugh's dissent. He talks about the difference between literalism and taking the words apart and say, well, literally, what does this word mean? If I had a German flag that was produced in an American factory, is that an American flag? Well, okay, technically, if you took the words apart and said literally, okay, yeah, it's a flag that was made in America, but that doesn't make it an American flag. We know what that means. So when a judge is reading a legal document, they shouldn't be taking it apart, dissecting it in a mechanical way like that. That does violence to the actual usage of the English language. We have to use the words the way the legislators would have understood them. And nobody in this case is arguing that the people who passed the law at issue here, the 1964 Civil Rights Act, thought that it covered sexual orientation or gender identity. That's 100% clear because they considered adding that. They considered adding sexual orientation discrimination to that law, and they voted against it. So when they were talking about discrimination on the basis of sex, they meant what everyone meant until yesterday, which is discriminating against someone because of their biological sex, because they are a woman or because they are a man. So there's a lot of states that have laws protecting against discrimination on the basis of sexual orientation. There are many federal laws that protect against that kind of discrimination, but it's simply a different thing. And to pretend that they are identical is not fair to the reading of the law. It effectively changes that law from the one that was passed by our legislators. We know, Schoolhouse Rock, you have to be passed by the House and the Senate and get signed by the president. That's how we change law. You can't change law by simply going back and kind of looking up and redefining this word effectively by taking it out of context. And that's unfortunately what happened with Gorsuch's decision.
Right. And that's a very good point as well. The strict kind of robotical interpretation, because the very robotic interpretation that he had, which really surprised me, because there were Second Amendment cases that they have declined to get involved in, and instead, push that back on the states and localities, or, things that really Congress should address. And this seems to be one of those things that this is ultimately something Congress should have taken up. And I don't know why they haven't pushed this through as in the House now that Democrats control the House. I'm not quite sure why this hasn't been a priority, but for them, if it's held so closely to the heart. But this is legislating from the bench, is it not?
Well, yeah, and actually there's legislation that's under debate right now that the House has looked at that does exactly this. So, that's because the law did not before include sexual orientation.
Right.
And I'm not arguing one way or the other on what the right policy here is. My concern is
Right.
who decides.
Right.
Do we have our constitutional system where it's our elected legislators who get to make those decisions, or are we going to turn that over to unelected judges? That's a very dangerous proposition.
I mean, this may almost sound absurd to go this far, but it is kind of a slippery slope, because that's normally what that kind of tends to happen. And we've seen that in cases before, because now you have this situation with a Supreme Court justice who is reinterpreting to a modern era verbiage that was very clear at the time that it was written, when this could be addressed congressionally. But what do we have to fear in terms of going back through all of these other different decisions and different cases and relitigating them on the basis of this action?
Well, Justice Alito, in his dissent, there were two different dissents, and in Alito's dissent, he goes through really a parade of horribles of the kind of impact this could have. And these are all questions that if you did this through legislation, through the Congress, they would be able to come up with a compromise position to try to figure out how to balance various interests like freedom of speech and freedom of religion with the concerns about discrimination here. When the courts do it, you don't get that. So here are the issues that Alito predicts are going to come up before the court. Things like bathroom and locker room usage. If discrimination on the basis of sex also includes discrimination on the basis of gender identity, then that really opens the door for saying, okay, biological men must be allowed into women's restrooms, and that, along with all of the safety concerns that go along with that, whether women's sports could continue as we know them, would women's professional sports be required to allow biological men who identify as women to also compete? That would put biological women on a very uneven playing field and may eliminate them from the athletic world altogether. You have questions about religious freedom. What about churches or synagogues or mosques? How about their hiring decisions? Can they ensure that their employees are living in accord with the principles that those religious groups espouse? What about churches, or about church schools, rather? What about religious schools, and can they continue in their hiring decisions to teach the same things they're teaching children in the classroom about their beliefs about the world? About the Hobby Lobby case, remember in that situation, a Christian businessman didn't want to be forced to pay for abortifacient drugs for their employees. Under this interpretation, you could argue that business owners have to then pay for costly sex change surgeries for their employees, even if that violates their personal religious beliefs. So all of these questions, it's not at all clear what the answer is going to be, and they're going to have to be litigated one by one in the courts. That's going to be not only very costly and risky for the businesses and the individuals involved. I think it's also a real concern, because you're going to have a range of different outcomes across the country, and you're not going to have a consistent answer to how are we going to be balancing these important concerns. Anytime you have a major change in the law like this, it unleashes a flood of litigation. But I think the fact that that's going to be coming down the pike just illustrates that this is not what the law always said. If it were, we would already know the answers to these questions. What we're seeing here is something new, and it's a sea change in the law. Now, that's something that can be done properly through the legislative branch, but it never should be done simply by the majority vote of unelected judges.
This is so disappointing, because I know that everyone had high hopes for Gorsuch. Do you consider him a disappointment? Does this make you more? I'm not as familiar with his backstory and his jurist history as I am Kavanaugh's. What do you foresee for Gorsuch? Is he going to kind of float to be that moderate on the Supreme Court, or do you think that he is a disappointment? Is that serious enough an issue to have for him to be judged a failure, I guess?
I was very supportive of Gorsuch when he was nominated and confirmed, because he has a very long track record of not being a judicial activist, of hewing closely to the text and originalist understanding. I think this is an unusual circumstance for him that he would get it so wrong. I think it's not because he said, well, I want to update the law. It's because he got the idea of how to even do textualism wrong, where he's looking at this, again, robotic way of doing it.
Yeah.
I think that is a better result than someone saying, well, I just think we need to update laws. And there are, unfortunately, judges who agree with that prospect. So Gorsuch overall, the justice on the court that he most agrees with is Thomas. He really does have that originalist and textualist approach. Every justice is kind of going to disappoint us at times. Justice Scalia had decisions.
Clarence Thomas never has. I have to interrupt you, Carrie. Justice Thomas has never disappointed me.
I can think of at least one decision where he later changed his mind. So he must have been wrong at least once. But I honestly can't think of any other. So I'm with you on that. But these are fallible human beings. They're going to make mistakes. I do think that in general, what we see from Gorsuch is someone who is very committed to textualism and originalism. He's not always going to get it right, and I'll be the first one to call him out when I'm not going to paper it over when he gets it wrong. But I do think overall he has been a really impressive judge in terms of returning the court to those things. I think in this round. Maybe not so much, but I do think we're going to continue to see that from him going forward. Yeah,
Carrie Severino, #1 best-selling author of Justice on Trial, which is the Kavanaugh book, which actually everybody needs to get this book anyway, but it's the definitive book on the whole storm around Brett Kavanaugh. Fabulous book, Carrie, by the way. I read it, and it was just absolutely wonderful. And you can find her also at Judicial Network, at JCN Severino. Carrie, thank you so much for your perspective. And I so appreciate you being so forthright on social media, because it was just, very logical, very straightforward, because even legal pundits today, I know everyone is getting into the trend of being super emotional, and you were so zeroed in, and it was so compelling. So terrific work, and thank you for your time.
Thank you. Have a great day.
You too.